thinking, probably I talk about something on international cooperation. This is a rather important principle in the field of space law, not only in the public field, but also now when we talk about space commercialization, space privatization. So international cooperation has always been a very important principle. So international cooperation has always been a very important principle, starting from the very beginning. We know that the first man-made satellite was launched in 1957. Very soon, the UNGA issued resolution calling upon the international cooperation, and then to be continued by several other UNGA resolutions, like the 1963 resolution, and also later. But of course, this principle has also been put out in the 1967 Outer Space Treaty. So now we have always thinking that probably the principle of international cooperation can be considered as part of customary international law. But if we look at the 1961, 1963 resolutions and the 1967 Outer Space Treaty, the principle itself is very simple, straightforward, very general. Fortunately, in 1996, this principle has been further elaborated, and we can have further ideas about the understandings and how to implement the principle of international cooperation. But that's not the major part that I would like to discuss today. Today, I would like to look at the mechanism to realize the international cooperation. And I argue that international agreements is one major and effective mechanism for international space cooperation. As such, it's necessary to examine and assess the role of international agreements, of international cooperation in space activities. I refer to.
Yes, sir.
Yes, thank you. Thank you very much.
Yeah. Thank you, sir.
Okay, thank you very much. So let me open to, I have just gone through this slide, then we move to this slide. So we look at the role of international cooperation in space activities. We realize that from the very beginning, the international principle of international cooperation has been put into operation. This can be exemplified by the establishment of the committee to deal with the outer space. So we, in 1958, we set up an ad hoc committee. 1 year later, this committee became a permanent body to deal with the peaceful uses of outer space. And later on, under the framework of the UN, we also reached the 5 international treaties. The principle of international cooperation was first put down in the UNGA resolutions. 1963 resolution is one of the most important resolutions that we will need to look for. So it put down the principle of international space cooperation, which was further emphasized in the Outer Space Treaty in the Article 9. But as I have just mentioned, the 1996 UNGA resolution regarding the understanding and implementation of the principle for international cooperation was very important documents. It put down, if we read through this document, we can find out that this document put down formal requirements for international space cooperation and substantive requirements for international cooperation. When we look at the formal requirements for international space cooperation, we mean that you are free, that a lot of flexibility in dealing with the formality of international space cooperation. Space cooperation can be carried out between governments and governments, and non-governmental entities and non-governmental entities. It can also be cooperated in the areas of commercial field or non-commercial field. It can be conducted on global level, multilateral level, regional level, or bilateral level. Furthermore, international cooperation can be conducted among countries at all levels of development. That's a formal aspect. The UNGA resolution further defines a substantive requirement. One basic requirement is a principle of party autonomy. So the states are free to decide on the appropriateness and effectiveness of certain modes of cooperation. Based on this requirement, we can see that the member states can really have their own will put down in agreements. So it has been further elaborated and have been divided into 3 substantive requirements. First, space cooperation should be carried out on a mutually acceptable basis, showing the real intention of the cooperating parties. Second, space cooperation should be conducted on an equitable basis. The terms and conditions for cooperation should be fair and reasonable. But this kind of equity does not mean that everything should be equal, but we will need to look at the real equality. That means we will need to look into the needs of the developing countries. Now, these few documents provide the basis for our discussion, and it indeed leads us to think about what will be the areas for cooperation and how to move ahead for cooperation and what kind of model we will need to look at. So if I use this, the 4 levels of cooperation as a theoretical basis, we can see that international cooperation can be conducted at different levels. The lowest level will be coordination. So the international agreements can be used to facilitate or to coordinate. And then the second level is augmentation. The states can use international agreements to build on the original project and contribute to the development of the project. And then the third level is interdependence. The states contribute to the operation of the project, but still controlling their own part of the contribution. And finally, integration, which means the full cooperation. And this has been very well shown in various cooperative projects, such as the ISS, International Space Station, and other cooperative projects. The parties to the international agreements on space cooperation can include governments, space agencies, private entities, etc. Now, if we look at the role or the function of international agreements, I basically look at the 2 types of agreements. One is multilateral agreements. The other is bilateral agreements. Multilateral agreements can play several very important roles. The first one is to deal with the space activities, to regulate the space activities, to facilitate, to promote the development of space activities. So the binding international treaties and non-binding multilateral agreements are playing very important role in this regard. And in the past few decades, we can see that non-binding space-related multilateral agreements are increasing and playing increasingly very important role. The advantages of non-binding agreements is that it can move ahead relatively quickly and is persuasive in reality, and the members have a moral obligation, although not a legal obligation, to get things done. And these kind of documents can also help the development of customary rules in the space field. So that's the first function of multilateral agreements. Second is for the establishment of international and regional intergovernmental organizations, such as ITU, WMO, and EPSCO. Third, it can also create a common forum for discussion. So like the IADC and also other forum for discussion. So it is not a permanent body, but it come up with something for the members to discuss, and they can issue some declarations, can come up with some conclusions and recommendations, which also play a very important role in the regulation of space activities. And lastly, it can also be used for specific space objects, space projects like the ISS, IGA, intergovernmental agreements. So that's the 4 major functions for multilateral agreements. For bilateral agreements, it will be rather important for the 2 countries on certain or specific projects. So this slide basically gives you general ideas that the 2 countries, they can reach agreements for certain space activities, for certain specific space project, for certain commercial services. So that's the role functions. Now, if we look at the multilateral agreements and bilateral agreements, we can have some kind of views, or we can have some assessment. First, space activities are covered in these agreements are very wide. Various types of activities have been covered. It includes almost all aspects of our daily lives already. The space cooperation and space activities are not only meaningful to the exploration of outer space, but also can exert strong influence on social, economic, and cultural aspects of our daily lives. If we examine these agreements, we can see these few items are included in these agreements. First, the application of the 4 UN space treaties and international law, cross-waiver of liability, exchange and transfer of goods and technical data, IP protection, and cooperation on accession procedure and dispute resolution. These are the few provisions we can frequently find out in the existing multilateral and bilateral agreements. It has been used to facilitate the cooperation. We can see that various forms of international agreements have been adopted. This can include like government-to-government framework agreements, intergovernmental agreements, MOU, implementing arrangements, letter of agreements, statement of intent, etc. So bilateral agreements, multilateral agreements can function in a wide range of space activities. It can be taken in various forms. We, on the one hand, look at the flexible approach, but also we need to take a pragmatic approach for the space, for the solution of space-related legal issues. So that's why we will need to think about what kind of mechanism should be set up for multilateral cooperation through the examination of existing multilateral agreements and bilateral agreements. What can we do? Normally, we can see that in the conclusion of multilateral agreements, we will need to be mindful of several very important principles. We need to create a trustful cooperation atmosphere and search for the compatible or common objectives between or among the states. We need to remind the states of conducting space cooperation in an open and flexible manner and carry out relevant activities in good faith. And there are some rules which should be well prepared beforehand. Now, for bilateral agreements, and sometimes we also touch upon the regional agreements, we can see that normally this will be rather useful for the states with common interests to reach relevant agreements for certain projects, for certain space activities. Now, how to push ahead for these kind of bilateral agreements? Probably it will be good that we can put down several model provisions which can guide the member states to reach the agreements. So for example, we can have sample provisions regarding the export control, custom clearance, financial arrangements, exchange of personnel, etc. Now, based on these, what we have observed, we can find out that, first of all, space cooperation has been always a very important principle. The detailed cooperative activities, scope, methods, and styles are left to the member states themselves. So that's kind of flexibility, which can really show the free will of the parties. We also need to be mindful of two dimensions of the cooperation, vertical and horizontal. Vertical aspect, we mean that a state has obligation under the space treaties to carry out space cooperation, which should be included in its national space law. Horizontal aspect, that means the conclusion of bilateral and multilateral agreements to establish, strengthen, and further expand space cooperation with other states. So this can, of course, help to build trust and confidence among states. Now, bilateral and multilateral agreements could set up specific framework or mechanism for space cooperation. Such kind of cooperation can further enrich space or so-called state practice and contribute further development of space law or realization of the rule of law in the space field. Now, to conclude, international cooperation has been a very important principle from the very beginning. In 1957, 1958, we can see a lot of rapid development under the UN regime. And UN corpus plays a very important role in overseeing space cooperation at the international level. Then at the regional level and bilateral level, we can see a lot of agreements have been concluded. And these agreements are playing an increasingly very important role. In order to facilitate further and wider use of international space cooperation through agreements, a model agreements or provision might be a good way to push ahead, to facilitate, to assist the member states in negotiating their cooperative agreements. Wider and more frequent use of international agreements in space cooperation would, in the end, help to realize the ultimate goal of peaceful uses of outer space. So this concludes my presentation. Thank you very much. I'll welcome any questions you may have. Thank you.
Thank you so much, sir, for the presentation. I request the participants to please drop your questions in the chat box as we have followed in the last sessions. Thank you so much again, sir.